Okay, I told you I was going to go over the rules of professional conduct with you, but I specifically told you about some states removing Rule 3.8. All right, so I decided maybe I should save myself some time and see if the internet knew, so I asked that question. What states removed Rule 3.8? Okay, no states have completely removed Rule 3.8 of the American Bar Association Model Rules of Professional Conduct. Remember, I told you the model rules of professional conduct are basically what every state is supposed to go by. That's, any laws repugnant to the United States Constitution. And this is in line with effective assistance of counsel. I've been trying to tell you people, the Sixth Amendment of the United States Constitution guarantees you effective assistance of counsel, and that's a double-edged sword. That's just not for your lawyer, but that's to ensure the effectiveness of the court. So the legal responsibilities of all lawyers and judges in a court of law are in the Rules of Professional Conduct and the Code of Judicial Conduct. And reporting misconduct is mandatory in both the rules and the codes. So the judge's failure and the opposing party, whether it be in civil court or in criminal court, state's attorney failure to report misconduct is misconduct. It's mandatory to report misconduct. So you can cite the judge for judicial misconduct, the state's attorney or opposing party for multiple violations of the rules of professional conduct, specifically not reporting your attorney for ineffective assistance of counsel because your attorney didn't abide by the rules. It's commonplace. Okay, but this Rule 3.8, the state's attorney is notorious for violating. You just don't know. Okay? You just don't know the law. It says California is the only state that has never adopted the ABA model rules of professional conduct, including Rule 3.8. There's a breakdown based on the search. Rule 3.8, special responsibilities of a prosecutor, imparted American Bar Association Rules of Professional Conduct. California has its own rules of professional conduct and has not adopted the American Bar Association model rules. Most other states have adapted some forms of the ABA model rules with or without comments. Some states have modified Rule 3.8 but haven't completely removed it. For example, Illinois has a specific rule regarding prosecutors' responsibilities which aligns with the spirit of Rule 3.8. Wisconsin is the only state mentioned that has adopted the specific amendments and G and H to Rule 3.8 post-conviction innocence. In summary, while no state has removed the concept of prosecutorial ethics outlined in Rule 3.8, California is the only state that has not adopted the ABA model rules which the rule is based. Some states have adopted or slightly modified the rule for their own jurisdictions. Okay, American Bar. I want to go to Illinois. Okay. Supreme Court rules. Well, that didn't work out. Article. Let's go down here. .8. Okay. I like to use Illinois 3.8 because it's slightly more informative. Meritorious claims and contentions. You can stop a slap suit because it's mandatory. You read 3.1, meritorious claims and contentions, candor towards the tribunal. That's the easiest way to stop a slap suit is use the rules against the lawyer that's inciting. Because I had a lawyer say, first time somebody stole my identity, took out a loan, and the lawyers tried to call me, say, hey, you just give us the money and, we won't sue you and you won't have to get a lawyer. I said, no. Says, no. I says, where'd the money go? Well, legally, we can't tell you that. And I said, what do you mean you can't tell me that? In fairness to the opposing party and counsel, excuse me, I said, in fairness to the opposing party and counsel, expediting litigation, I says, would be competent. I mean, that would be diligent. And see, I just threw a bunch of rules at them, and they said it didn't go to me, and they apologized and they withdrew. So you can't retort the party, fairness to the opposing party, impartiality and decorum of the tribunal. That rarely happens, and that's also a violation of the Code of Judicial Conduct, not being impartial. Fair, bias, trial publicity. You see a lot of lawyers as witness. Okay, Rule 3.8, special responsibilities of prosecutor. Whoa, that's like really tiny, and I'm old. Okay, but the duty of the public prosecutor is to seek justice, not merely to convict. The prosecutor is, in a criminal case, shall refrain from prosecuting a charge that the prosecutor is not supported by probable cause. You ever see that judge in Texas where he gives those people a probable cause hearing and there's no probable cause to proceed for the case, so he throws it out? Every time I tried that with lawyers here in Illinois, I used to go to a lot of different courts, criminal courts, 51st and Wentworth. There used to be one on 13th in Michigan. They moved it to State Street in the police station or something. And and always somebody threatening me because I go there with the rules and the codes and go through this with defendants. And I tell them this, and criminal courts, they don't like probable cause hearings. It's too quick. It's too short. The case could end that day. And public defenders, they won't ask for it. They'll tell you, here, sign this, and you can go, and you'll walk out with a felony. That's ineffective assistance counsel to the extreme. They could go to jail with that. Remember, they took an oath to do this, and violating the oath is punishable with fines, removal from public service, and incarceration in case of death penalty. Okay, so that's in a couple of videos I showed you the law, some other laws. And refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. Make reasonable efforts to ensure that the accused has been advised of their rights, and prosecute for obtaining counsel has been given reasonable opportunity to obtain counsel. Not seek or obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing, in which they will. I mean, the law clearly states that they can't speak to you without, legal representation, but they do it anyways. That's breaking the law. That's violating the oath. Violating the oath requires fines, removal from public service, and incarceration. So, if you read the law, you'll see how often and how easily your public servants will break the law. And remember, the rules and the laws, the rules and the codes apply to all attorneys and judges. So no matter who they work for, the public interest, serving the public interest is first and foremost. They took an oath to do that. That's a legal binding contract, okay? Just as well as this is. There's a lot of stuff that isn't being done here. Not seek to obtain from an unrepresented accused. Okay, went through that. Make timely disclosure, okay, to the defense of all evidence or information known to the prosecutor. That's expediting litigation. I showed you that rule. The prosecutor tends to negate the guilt of the innocent or the accused and mitigates the offense. So if they have evidence showing your innocence, they should present that evidence saying, hey, there's no probable cause because this person is innocent, but they won't do that. Okay, but just read it yourself, okay? And if you got like a criminal case going on, you not just have a case against your attorney for ineffective assistance of counsel, you have a case against the attorney for not doing this, okay? I mean, and that's a conspiracy against rights under the color of law. And I told you, Clarence Thomas just stated that qualified immunity does not exist if you can prove conspiracy against rights under the color of law. And since nobody in the courtroom abides by the rule of professional conduct and the code of judicial conduct, you prove the conspiracy against rights under the color of law when you cite your attorney for ineffective assistance of counsel and the judge for judicial misconduct for failure to report misconduct, the state's attorney, the opposing party, for failure to report misconduct. Reporting misconduct is mandatory. Failure to report is misconduct. And then your attorney's supposed to report them for not reporting him. I mean, it's a vicious cycle if you just read the rules. I mean, it's easy to prove a conspiracy against rights under the color of law, no matter what law it is, because nobody does this. Not subpoena a lawyer and grand jury. Well, I wish I could. My vision was better. I'm on my phone right now. Okay. Let's go down here to G. When a prosecutor knows of new, credible, and material evidence concerning a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall make timely disclosure of the evidence to the appropriate court and authority, and if the conviction was obtained in that prosecutor's jurisdiction, 2I, properly disclose that evidence to the defendant unless the court authorizes delay, and I undertake further reasonable, I can't see that well, investigation to make reasonable effort to cause an investigation to determine whether the defendant was convicted of the offense that the defendant did not commit. When a prosecutor knows of clear and reasonable evidence establishing that the defendant in the prosecutor's jurisdiction was committed of the defendant did not commit, the prosecutor shall seek to remedy the conviction. Okay, so people quite a few times told me they had exculpatory evidence. If I knew a good civil rights lawyer, I said no, but I know somebody whose job, their legal responsibility is to overturn that wrongful conviction. You ain't got to spend a penny. And then I tell them about this. It's their job to overturn a wrongful conviction. If you have exculpatory evidence, you just step on down. Now, some people say that I've talked to throughout. It doesn't say in my state. Yeah, but that's not in the public interest. That's in the interest of the bar. They must do what's in the public interest. And if you read the preamble, which is law, it'll tell you that. So you could say, hey, in the public interest, in my interest, I am the public. This is in my best interest. To not have that there is in the interest of the bar, specifically the state's attorney's office. Okay, that's a reasonable argument, and it's a quite legal one. Set of precedents. Listen, I had my therapist. I went to therapy for PTSD, but it wasn't about what happened to me. It was what was happening to all of you. And I've always found it disconcerting and heartbreaking. And even though I managed to keep myself out of the meat grinder, I did my best to help others. And now I'm using the internet to do that. So I'm hoping somebody's listening and teaches others as well as this is people. Just share this information if you have to. do some videos, tell your story, be the hero in your own story using the law. I'm just showing you which laws you can use, okay? I'm not doing this to find, followers that follow the law like me, to remain true to it. You know, I may not be a public servant, and I didn't take the oath to do this, but when I took a pledge of allegiance, I pledge allegiance not just to the flag, but what it represents, the U.S., the Declaration of Independence, the U.S. Constitution, and who that was written to serve and protect we the people. So I'm doing my best to protect you, all right, from your public servants. We are tired of our hands being bitten. Okay, a prosecutor's judgment in good faith. The evidence does not rise to the standards stated in paragraph C. Okay. Comments. Okay, over here. In 1935, the United States Supreme Court described the duty of a federal prosecutor in the following passage. United States attorney is a representative, not of an ordinary party, I can't see it, to a controversy, but sovereignty, which obligation is to govern impartially, is a compelling as to obligation to govern at all. And those who interest. Therefore, criminal prosecutor is not there. Criminal prosecutor is. I'm sorry, I can't. Oh, okay, there you go. United States attorney is a representative not of an ordinary party to controversy, but of a sovereign whose obligation is to govern impartially, and it is compelling to obligation to govern at all, and whose interest, therefore, as a criminal prosecutor is not that it shall win a case, but that justice shall be done. As such, he is a particular and very good, definite sense to the servant of the law. Okay, you're a servant of the law. Not to a party, not to a politician, definitely not to Wall Street. You are a servant of the law. Okay. Servant of the law. The twofold and which the guilt shall not, the twofold aim is which that the guilt shall not escape and the innocent suffer. He may prosecute with, it's just so small. He may prosecute with earnestness and vigor indeed. He should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is his duty to refrain from improper methods calculated to produce a wrongful conviction, and it is to use every legitimate means to bring about a just one. That's what I was trying to, and that makes Brady versus Maryland redundant. If you're familiar with the Brady violation, that's where they withhold exculpatory evidence to procure a conviction. They convicted a guy of a crime. He wasn't even there, but he was with the guy after the guy committed the crime and committed a crime with the guy afterwards. So they committed a crime together, but the guy committed a crime before he picked him up. So they convicted both of them of both crimes. But later on, it was proven that the guy, Brady, didn't have knowledge of the first crime, wasn't there, didn't know nothing about it. So, but it was later found out. So he was still in prison for the crime he got convicted for. Actually, he was actually in, which there was no doubt. But the one he wasn't even present or had no knowledge of, he reversed the conviction on that. So that's, I mean, this basically makes the Brady that redundant. Okay, but that's why I wanted to use the one from Illinois, and feel free to use it. Remember, it's in the public interest, and the law, that's part of the public trust. You know, as I spoke to you before about the public trust doctrine, which basically means the public trust fund. Okay, so we went there. Okay, so if he violated special rules of the rule 3.8, there's so many. Truthfulness in statements to others. Oh, you could use that one. Communications with a person. Okay, no. Dealing with an unrepresented person. See, it says right there, that's against the law. You can't do that, and it tells you that. Respect the rights of third parties. Responsibility of partners, managers, and supervisory lawyers. So you want to use that too. Responsibilities of a subordinate lawyer. So you want to use that too. Responsibility regarding non-lawyer assistance. A lot of times they do stuff to cover up a cop's misdeeds. So you want to use that. You know. Professional independence of a lawyer. Okay, so I mean, just the lawyer, the prosecutor violating Rule 3.8. Okay, you can call a lawyer as a witness. Impartiality and decorum of the tribunal. Violated that. If you violated Rule 3.8, you violated Rule 3.5. Then thus violating Rule 3.4, fairness to the opposing party. Violated 3.3, candor towards a tribunal. Always happens. 3.2, expediting litigation. That means when they walk into court, they got to be prepped. So when it comes to, you know, like in a probable cause hearing, somebody comes there with a case, they got to have something to prove that there is a case. And if they can't, then the case gets tossed out. That's expediting litigation. All right, and the judge is saying, hey, you came here with nothing but, you know, a wing and a prayer. You know, he said, she said, and there's no proof from either party. No, it's meritorious claims and contentions. Okay, so then there's another rule they violated. Okay. Advisor, they violated that. Or even duties to a prospective client. They violate that by not telling you all this. Okay. And the preamble tells you they're supposed to discuss this law with these, you know. That's how you give informed consent. You need reasonable information to make an informed decision to give informed consent. And that's in the preamble. And how are you going to give informed consent if nobody's went over his or her legal responsibilities to you, okay? And these are the legal responsibilities of the opposing party as well as the judge to make sure all this happens. Nobody's doing it. Why? Why? You should be asking yourself. Okay. Required records, trust accounts, and overdraft notification. Okay, so when you read over the public trust doctrine, consider this: trust accounts. Okay. People in conservatorship, what they do to Britney Spears, what was that called? What they did to her is wrong in so many ways, and there's so many violations in here. And she can actually recoup anybody in conservatorship, probate, because people, if you want to get your kids back, remember, nobody in court's doing this. The lawyers working for you are working against you if they aren't discussing this with you, because you can easily beat the opposing party because they're not doing this. And hey, judge, how come nobody's doing this? You're supposed to report misconduct. It says in the Code of Judicial Conduct as well as the Rules of Professional Conduct, reporting misconduct is mandatory. Your failure to report misconduct is misconduct. You are in contempt of the very court you're presiding over. Your failure to report thus far that's multiple counts of contempt. Your failure to report thus far, you not reporting today, would further that contempt. That would add a charge of contempt of court. You not reporting them not reporting you, each other. Everybody's supposed to report each other and themselves as well, because everybody violated the rules and the codes, thus proving a conspiracy against rights under the color of law, which that's in violation of a federal law. I'll get to that in a minute. Okay. But wow, I mean, there's a whole lot of law breaking in a court of law. You just don't know it because you ain't looking. That's why I keep telling you, child with a diminished capacity. Oh my goodness, what the hell is going on out there, you know? I've seen some trust fund accounts raided. People, you gotta learn who you're dealing with when you're dealing with the law. Arbitrators, I dealt with them, they got mad, you know, told me, oh, well, you gotta understand the judge don't like this, the judge don't like that, you know, this lawyer over, you gotta understand their opinion. I says, you know, maybe I could hear him better if, you know, your head wasn't so far up their ass. And the guy that was in there with me, oh, I gotta go. He thought I was gonna get arrested or beat up by the lawyer and arbitrator because I was the way I was talking. But then when I spoke on the rules and the codes, everybody got mad, ran out. The judge ain't gonna like this. When I went out there, judge, did you settle the issue? No. He won't give in. The judge says, oh, yeah, so we're going to take this to trial. I said, yeah, I was pro se. And he says, okay, you know how long? And the clerk's patting the patent. What? Showed him. He says, oh, this is set for a jury trial. When I filed for an appearance, I filed for a jury trial. And thus the case was dropped. But still, it was a conspiracy against rights under the color of law. It's just reporting that with the ARDC I did. Illinois, well, now it's the IARDC, Illinois Attorney Registration Disciplinary Commission, multiple times in the 80s. You know, first year I filed, I don't know, a couple months every week, and then the rest of the year once a month, and I threw in how, you know, the conspiracy against rights, how the judge assisted the attorneys assisted the judge, nobody reported misconduct, everybody was violating the rules and the codes multiple times, etc., etc. Okay, so I mean, it's easy, people, it's easy, you just gotta read the law. Okay, there's so many laws here to be broken. Like I said, the rules of professional conduct, you can't use every law in here in every court, but in every court you can use these laws. Not all of them, but some of them. This is accountability. If you want accountability, you got to go out and get it. Like, you know, take law in your own hands. I'm not talking about no guns. I'm talking about these big guns, the rules of professional conduct. And the codes of judicial conduct are even bigger guns. That's when you blow them out of the water when you start using the codes against the judge. Like I said, you could literally walk in the court and tell the judge, Judge, Your Honor, and, you know, it's mandatory to report misconduct in both rules and the codes. My lawyer violated the rules of professional conduct on, you know, multiple occasions, multiple times. You know, and it's mandatory to report misconduct, and your failure to report misconduct thus far is contempt of the very court you preside over, yada, yada, yada. I gave that speech many times. It's in my other videos. Okay? Diligence, you know, so that requires this to be done quick, fast, and hurry, otherwise expediting litigation. Failure to expedite litigation is failure to be diligent. Okay? Did anybody communicate any of this to you? All right, rule 1.4, communication. Okay, did anybody communicate? See, this is how, when I use these laws, I said, yeah, okay, failure to expedite litigation, that's a lack of diligence. That's a clear show of, well, let's not say competence. If you're not competent, that makes you what? And there would be people standing around. I was talking to a public defender. I said, that makes him incompetent, right, y'all? And people started laughing, and he started yelling at me and stuff. And what, are you a lawyer? You ain't no lawyer. I said, neither are you. Well, legally, you can't be. You're not abiding by the law. Well, what do you think you're doing? I says, what you're supposed to. Protecting our peoples. It doesn't matter if they're black, white. It was mostly a bunch of black people and a couple Latinos outside the court. People want to know what the hell I was talking about, why I got chased out of the court, why the judge threatens somebody with contempt of court. But I was just trying to push people to ask for probable cause hearing. I had a copy of the rules and the codes with me and complaint forms where to file such complaints to have these people legally removed. That's filing complaints with the ARDC and the Judicial Inquiry Board. But even when you file complaints, they won't. And I've always used the conspiracy against rights under the color of law to assert my authority over my public servants. And these some bitches keep biting my hand. They've been biting my hand since 1979, people. Shit hurts. I got them to stop doing it to me. And every day my therapist tells me, oh, don't watch the news, eventually don't watch TV, don't go on the internet, stay off of social media, Man, I worry about you like a father worries about his child. Granted, I may not know you, but, as a Christian, by his command, love thy neighbor. That's what I'm doing. Showing some love. That's all I'm doing. Competence, right? So not doing any of that is a lack of competence. So the book of incompetence, you're gonna show how incompetent everybody was. See, I was telling you how I've had fun throughout the years talking to lawyers, and people always thought it was casual conversation. No, I was just using the rule in their simplicity. So lawyers will tell you, hey, that's not what that means, but if you lose, use the letter of law. My dad, when I spoke to him about the law, he understood everything. He was well versed in the Constitution. His linguistic talents weren't up to par because English was not his first language, but his reading comprehension skills were on compare. And he understood this. So if they try to tell you what competence means, all you do is click it open, look at it. Legal knowledge and skill. Sure, they have that legal knowledge and skill, but they didn't use it because the law clearly states that these are a whole bunch of laws that they got to abide by, and they ain't doing it, And then go into the preamble and scope, people, okay, because that's some tasty stuff. I mean, just imagine you're a carnivore, right? And you love a rare steak. Okay, this is the rarest steak. You want to see blood? You're going to see blood when you read that preamble. People, instead of hating, you like to tell each other what to do, how to vote. Stop that. Mad at each other because you vote for different parties when neither party is doing this. They all got lawyers, right? And the lawyers would tell you the importance, of the law. Okay. This is one of my favorite parts. 11. That's scope. 11. To the extent of lawyers meet the obligations of their professional calling, the occasion for government regulation or is alleviated. Self-regulation. Okay, where is it? Remember that. 12. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to assume that its regulations are conceived in the public interest. That means the laws are conceived in the public and not in furtherance of parochial religious or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also aid in securing the observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves, okay? The public interest which it serves. That's you. There's a lot of things they aren't doing that's in your best interest. That's why it always, if you ever watch anything on the media, about the law, what's going on in court, Congress, legally everybody that serves the law, which everybody in public service, has to do what's in the public interest. Anything contrary to the public interest is unconstitutional, illegal. You're literally violating the oath when you do things that are in self-interest, that are interests of Wall Street, and not we the people, the public. Come on, people, get with it, all right? I got nothing but love for you. I'm trying to make this as short as possible. Okay, again. Okay. Law is against under the color of law. The provision makes it a crime for someone acting under the color of law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. It is not necessary the offense be motivated by racial bias or any other. Okay. And I tell you right here, Department of Justice, which is ridiculous. They're not going to do nothing unless you file a complaint. I mean, if I see this going on, I see this happening to you all the time. You got to ask yourself, what are they waiting for? Well, you didn't file a complaint. They got this thing, what we used to call back in the day, red tape, and this is what it is. And this red tape means unless you file a complaint, ain't nobody going to do that job. Okay. Makes it a crime for a person acting under the color of law, which is what you're going through no matter. That's how you got your kids taken. Okay? You want to do something about it. Like I said, first thing you got to understand is the rules of professional. It always starts with representing counsel, and it's easy to prove ineffective assistance of counsel. The lawyer that was supposedly working to help you get your kids back. And once you prove ineffective assistance of counsel, you prove the conspiracy against rights under the color of law. Easy peasy, automatic win, okay? It doesn't matter if it's murder. You could be sitting on death row and you can use. When I first wrote it up, in my first writings, I wrote it up as deprivation of rights under the color of law, a conspiracy to deprivation of rights. I called it ineffective assistance of counsel defense. I was only 18, 19. I didn't know what to call it. I was still learning, And, but now here it is on the internet. This was back 79, 80, 81, 82. Okay, you know what used to suck too? In the opening, in 79 revision, when I first read it, in the preamble, at the very top, very first paragraph clearly explained that the rules of professional conduct and the code of judicial conduct, the key elements of effective assistance of counsel, failure to abide by or do otherwise is ineffective assistance of counsel, guaranteed. Effective assistance of counsel guaranteed in the Sixth Amendment of the U.S. That's what made it easy for me. And they took it out because I use it so damn much. and then between the preamble and the scope, there was the informed consent clause. And it clearly stated, in order for them to get informed consent from you to proceed in a court of law, it's required to have, for them to get informed consent. In order for them to get informed consent, you needed to have reasonable information to make an informed decision to give that informed consent. And I remembered that. All right, I found it memorable. Okay, and they took it out because I use it so much, but it's still in the preamble. Okay, okay. I'm sorry, people. I don't mean to be yelling at you. Legal concepts of a conspiracy against rights of deprivation of law under the color of law are both addressed in the U.S. Code, specifically Title 18, Chapter 13, which covers civil rights and prohibits conspiracies to injure, oppress, threaten, or intimidate someone in their free exercise of their enjoyment of any right or privileges secured by the Constitution or laws of the United States. USA 18 U.S.C. 242 makes it a crime for anyone acting under the color of law to willfully deprive a person of rights protected by the Constitution or federal laws. See, so you see, a lot of my posts is just like piecing a whole lot of different laws together from different books. I tell people piece some of my stuff together. You're going to have to look at the different videos and choose which ones you're going to want to use, okay? Because it's talking, I talk about a lot of different courts. Sometimes people ask me questions, so I answer them, and it just winds up being for different courts. But the contingent, what's contingent in every court is the key common denominator, which is the rules of professional conduct and the code of judicial conduct to establish effective assistance of counsel. So if you don't take the rules and the codes with you, if you're just got a case going, you're going to lose. You're going to lose. You're always guilty on proven innocent. You know that. The only ones that innocent until proven guilty applies to our public servants, lawyers, judges, politicians, cops. And then they get qualified immunity, qualified candidate, just because qualified immunity is contrary to the rule of law. The rule of law is king of law and the nation of laws, thus repugnant to the Constitution. Any law repugnant to the United States Constitution is null and void, so said Thurgood Marshall. Excuse me for repeating myself, but I'm a little upset. As upset as a father would be when their child has been wronged. I'm sorry, I don't have any biological children, but a lot of children have come and gone throughout my life. I worried about them growing up, and I worry about them growing old. I worry about their future, their children's future, as much as I worry about your future, your children's future, your brothers, your sisters, your mother, your father. That's why I talk about so many different laws, trying to get you to understand what you're up against. Deprivation of rights. And who conspired to take them. Okay, Department of Justice. You can file with Department of Justice, okay? Who runs the Department of Justice? I forgot her name. Pam Bondi? Question her about that. I mean, seriously, people, I'm giving you things, what's that called? Content for, to be a social influencer, you know? I mean, hey, this would be something beautiful to talk about, people, all right? I talk about it all the time, but I've been pushing these issues since 1979, 80, 81, 82. I had some children that needed my attention, which was an extremely large road bump in my life. But once they went on their way, I went back to my doings, and this is what I do. This is how I do. This is what keeps me out of trouble. This is what's helped me keep other people out of trouble, learning the law. Okay, people, you can also file with the FBI. Talk to that FBI guy. What's his name? Cash Patel. Remember, Civil Rights Division. Statutes enforced by the Federal Civil Rights Status, Federal Bureau of Investigation. Conspiracy against rights. You can talk. Hey, listen, this is where sometimes I posted that. From Cornell. Okay, so that was on Rule 3.8, Special Rules of Prosecutor. All right, people. Look it up. If your state doesn't have it, go to Illinois Rules of Professional Conduct. Look up 3.8. Copy and paste that and use that. You know, it's in the public interest. It's in your best interest. And for anybody to deny you that would be denying you a valid portion of your right to due process. To deny you that would not be in the public interest, but in the interest of the bar. Okay, I'm just giving you some feasible and plausible arguments, which I've given many a times, have gotten plenty of people to back off, all right? If it works for me, it can work for you. It can work for you. Knowledge is power. Read to succeed. My dad used to ask me, he knew what I did. He was the only one that ever talked to me about the law. And is it worth it? You don't know these people. They don't pay you. They don't thank you. Is it worth it? Yeah, it's worth it. To fulfill a dream. I got a dream. One day our public servants will live up to the oath. The only way I can do that is teach the people what their legal obligations are. So I gotta do it. I gotta do it. At all costs. Cost me my life one day. Lucky I survived that. But I ain't gonna stop. You mean something to me. Every time I stepped in court, all of you were there. Not personally. Maybe not even spiritually. But I just always had this feeling when I took the Constitution with me, I had you with me. I had the power of the many. We the people. Every day I talked to lawyers and judges. We were one. I spoke as one voice for all. When I went to court, I didn't just claim I wanted what belonged to me. What you took from me, you took from what you took from me, you took from we. What you took from one, you took from all, and I want it all back. Not just for me, but for them. We all took an oath to the Constitution. The Constitution clearly declares we do what's in the public interest. We serve the needs of the many, not the greed of the few. When I pledge allegiance to the flag, this is what I pledge allegiance to. Not to break the law. Imagine that, any public servant, every public, you should remind them. Look up violating the oath. And remind them the consequences of violating that said oath. I wish nothing but peace and love for you, now and in your future. May your Creator always rain blessings. And for me personally, may you have a long life and good health. God bless.